Hello, this is Mohammad Majid from Shubhan. My student ID number is 190666914. Now I'm going to talk about my presentation. It's basically a case where I am talking about a case Petroleumeno versus the Republic of Ecuador. And in that case, I'm an arbitrator and talking about on behalf of a Petroleumeno. So without further interruption of any time, I'm going to start it right now. And to be very honest with you, I'm just not so adaptive in this platform at all. But I'm trying. I will try my level best, heart and soul, and let's hope for the best. I hope it will work for me. Um, Petroleumeno versus the Republic of Ecuador. Claimant's written submissions. The following submissions are forwarded on behalf of the claimant for this proceeding. These submissions intended to establish whether there has been a breach of the standards of treatment as propounded in the bilateral investment treaty of 1999 between the claimant's home state, the Kingdom of Netherlands, and the respondent. A copy of the relevant BIT has been appended with these written submissions for the tribunal's reference. Background and relevant facts. At all materials time, the claimant Petroleumeno in an oil and gas company, duly incorporated and registered in the Kingdom of the Netherlands, home state. At all material terms, the respondent, the Republic of Ecuador, is a country in northwestern South America, bordered by Colombia on the north, Peru on the east and the south, and the Pacific Ocean of the west. At all material times, Fuel for You is an Ecuadorian petrol company owned and controlled by the respondent. On 27 June 1999, the agreement of the encouragement and reciprocal protection of investment between the Republic of Ecuador and the Kingdom of the Netherlands (BIT) was signed. The BIT came into force from 1st July 2001. By the virtue of this BIT, both the contracting parties agreed, inter alia, to provide in its territory fair and equitable treatment of investors of the other contracting party. On or about 2008, the claimant invested in three petroleum blocks inside the respondent's territory host state. Subsequently, the claimant's factories were targeted by environmental and political protesters of the host state. Several processions were held outside of the claimant's factories. The claimant's buildings were vandalized by the protesters, and access to the factories were severely restricted. Such a serious disruption in the operation of the claimant's business resulted in the production of coming to a stop. The claimant vehemently submits that the respondent failed to assist the claimant adequately and at all in these disruptive circumstances. Moreover, the response letter subsequently imposed windfall taxes of 80% on petrol exports. This sudden rise in taxes and high tariffs mean that the claimant became unable to continue with its operations. Consequently, the respondent state-owned petrol company, Fuel for You, took over the operation of all three petroleum blocks of the claimant within 6 months. The claimant respectfully submits that the respondent has breached its obligation of providing fair and equitable treatment and non-expropriation under the VIT between the claimant's home state and the respondent, thus breaching several articles of the VIT. The merits of the claimant's claims are discussed in turn below. Breach 1. The failure to provide full physical security and protection. The respondent failed to provide a full protection and security to the claimant's investments contrary to Article 3, Subarticle 1 of the BIT. According to Article 3, General Treatment, Paragraph 1, each contracting party shall accord to such investments full physical scrutiny and protection as per Article 1, Definitions, Paragraph A of the BIT. The term investment means every kind of asset, including a property of movable or immovable goods. Therefore, the building and factory premises of the claimant, along with every movable and immovable goods therein constitutes as the investment of the claimant. A thorough reading of these clauses suggests that the respondent, being the host state, is under an obligation to take active steps to ensure protection of the claimant's investment from adverse effects. The adverse effects may stem from private parties such as demonstrators, employees, or business partners, or from actions of the host state and its organs, including its armed forces. The arbitral tribunal in Rumeil versus Kazakhstan stated that the presence of the full protection and security clause mandates the host state to ensure an adequate level of protection to foreign investment from physical damage. Moreover, the tribunal in Saluka versus Czech Republic further clarified this provision by stating that the full protection and security standard applies where the foreign investment has been affected by civil strife and physical violence. However, as detailed above in paragraph 6 of this written submission, written submission what I submitted earlier, the respondent has failed to provide full physical security and protection to the claimant's investments. The claimant's buildings were vandalized and access to factories were restricted. However, the respondent did not do anything to prevent and or mitigate such attacks on the claimant's investment. Therefore, the imperative issue is to assess whether the inaction of the respondent amounts to a breach of the standards of treatment under the BIT or not. The tribunal in Eastern Sugar versus Czech Republic stipulated the standard of protection that needs to be provided to the investors against violence stemming from third parties. The tribunal found that where a host state fails to grant full protection and security, it fails to act uh, to prevent actions by third parties that it is required to prevent. Moreover, in Vienna Hotel versus Egypt, where the police and other state authorities of the host state took no effective steps to prevent or compensate the adverse action against the claimant's investments by third party. The tribunal expressed that it had no doubt that the host state has violated its obligation to accord full protection and security as per the BIT. In the light of the above rationales, it is respectably submitted that the respondent has failed to provide a full physical security and protection, foremostly by preventing the attack from happening and subsequently failing to take any and or adequate effective action afterwards when the claimant's investments were vandalized, and thus breached the standards of the treatment under Article 3, Subarticle 1 of the BIT. Breach to a failure to ensure fair and equitable treatment FET. Article 3, General Treatment of the BIT, clearly mentions that the contracting parties shall ensure fair and equitable treatment of the investments of investors or of the other contracting party and shall not impair by unreasonable or discriminatory measures the operation, management, maintenance, use, enjoyment, or disposal thereof by those investors. More particularly, each contracting party shall accord to such investments treatment which is any case shall not be less favorable than that accorded either to investments of its own investors or to investments of investors of any third state, whichever is more favorable to the investor concerned. However, it is respectfully submitted that the respondent has failed to accord fair and equitable treatment to the claimant's investment. Understandably, there has been much academic and legal discussion about what is meant by fair and equitable. Frequently, it is said that their definitions are overlapping to each other. Professor Peter Matzlinski stipulated that to understand a famous both the behaviors of the aggressor and party being acted upon should be measured. He further stated that the concept of equity relates to a balancing process and weighing up what is the right in all the circumstances on the basis of the holistic understanding that holistic understanding of these terms. A FET clause is put in place to guarantee a standard governance on the part of the host country which compels is to act in a consistent manner free from ambiguity and in total transparency without arbitrariness and in accordance with the principle of good faith, ensuring that the foreign investors feel no discriminated in any manner. With the above submission, it is respectfully submitted that the respondent has breached the FET clause in the BIT. The imperative issue is to assess whether the actions in questions are in all circumstances fair and equitable or unfair and inequitable. Moreover, the respondent had unfairly levied a windfall tax of 80%, which has discriminately affected the petrol exports. However, as per Article 4 treatment in fiscal matters of the BIT, the respondent cannot impose taxes which results in the treatment of the investors being less favorable than that accorded to its own investors or to those of any third state who are in the same circumstances, whichever is more favorable to the investors concerned. This clause incorporates the concept of national treatment ante as a standard measure to ensure non-discrimination. These types of clauses are incorporated into the BIT to guarantee that that a level playing field exists between the local investors and the foreign investor. Therefore, the effect of these clauses will limit the host state respondent to make any negative discrimination between its domestic or national investors and the foreign investor claimant. However, it should also be borne in mind that in the unintended circumstances where the national legislation or regulation of the host state becomes factually less favorable for the foreign investors than the general rules of international law, a positive differentiation might be made between the foreign and national investor. In these circumstances, it might even be a duty on the host state to ensure that the foreign investor receives the standard of treatment it is entitled under the customary standards of international law. It is further submitted that the claimant had a legitimate expectation that the respondent would not suddenly increase his tax in such a manner that the claimant's operation petrol exports will be intentionally targeted. In reality, the introduction of the windfall taxes has disproportionately targeted the businesses involved in petrol exports, although the regulation does not directly discriminate between foreign and local investors. However, in reality, the business involved in petrol exports and predominantly foreign, thus the increased tax will affect foreign investors like the claimant more than the local investors. Therefore, respectfully submitted that this clearly breaches the equity clause and the standards of treatment prescribed in the BIT. And breach number 3, expropriation of the claimant's investment. As briefly stated above at paragraph 6, 7, and 8 of this written submission, what I submitted earlier, the respondent's failure to provide physical protection and treat the claimant fairly and equitably has resulted the claimant being unable to continue its operation in the respondent's three territories. Consequently, after 6 months of hardship on the claimant's part, the respondent took over the claimant's investment by a petrol company named Fuel for You, which owned and controlled by the respondent. It is respectfully submitted that such a takeover clearly amounts to expropriation by the respondent contrary to Article 6 expropriation and compensations of the BIT. The Article 6 clearly prohibits the respondent from taking any measures to nationalize and or expropriate or take any other measures having the same effect that deprive directly or indirectly investors of the other contracting party of their investments. However, the article does provide 3 exceptional scenarios whereby such an action will be justified, which are listed in subparagraphs A, B, and C of the article. There, if the measures are taken in public interest under due process of law, if the measures are non-discriminatory, or if the measures are taken against compensation. Moreover, it is respectfully submitted that the expropriation was discriminatory and one was carried out with a malified intention. It is further submitted that the respondent's unlawful expropriation has resulted in loss and or damages incurred by the claimant. However, the respondent has failed to provide the claimant with prompt, adequate, and effective compensation equal to the fair market value of the expropriated investment in exchange of the expropriation. In light of the above, it is respectfully submitted that the claimant's investments have been unfairly and unlawfully expropriated by the respondent, and therefore the claimant seeks adequate compensation from the respondent along with the appropriate interest. Conclusion: from the preceding paragraphs above, it is evidently clear that the respondent's actions amount to serve breaches of the standards of treatment prescribed in the Ecuador and Netherlands 1999 bilateral investment treaty. It is further submitted that the respondent has breached Articles 3, 4, and 6 of the BIT. It is respectfully submitted to the Honorable Tribunal to find the respondent in breach of the fair and equitable treatment and non-expropriation obligations, in breach of the BIT, and to issue an award stipulating the respondent to pay adequate compensation to the claimant. Thank you. to stay with me. Take care.